Hi, everyone, and welcome to Navigating the Pregnant Workers Fairness Act, PWFA. Today, we'll cover this new law, touch on the Pump Act, share real-world scenarios with you, and leave you with some practical tips and resources. Please enter your comments as we go, and we'll be sure to answer them at the end. This webinar is hosted by Healthy Horizons. We empower chest and breastfeeding parents at work and at home by setting up and maintaining lactation rooms, new parent gifts, milk shipping, and education programs, along with our parent-facing retail breastfeeding centers in the San Francisco Bay Area. We currently support employers in person in over 125 cities across the US and Canada. My name is Cassie Janikos, and I'm the Chief Operating Officer. My background is in mechanical engineering, system optimization, and operations. I'm going to hand it over to our CEO.
Yes, I'm Sheila Janikos. My background is in public health. I am a board-certified lactation consultant and a health educator, and my love is helping people with work-life balance around breast and chest feeding in the workplace.
Hi, everyone. I'm Jessica Lee. I'm Senior Staff Attorney at the Center for WorkLife Law. We are a research and advocacy organization housed at the University of California College of Law in San Francisco. And our mission is ensuring that nobody is forced to choose between their economic security and their family's health and well-being.
Hi, everybody. My name is Cheryl Lebetovich. I serve as Senior Policy and Communications Manager with the United States Breastfeeding Committee. The USBC serves as a coalition, bringing organizations together, including federal agencies, national nonprofits, state, tribal, local, territorial organizations, all across the nation, really coming together to do that collaborative work that is bigger than any one organization to address the policy systems and environmental barriers that keep families from being able to reach their own personal breastfeeding and chest feeding goals. We were very excited to be here today with some of our esteemed partners at Healthy Horizon and Center for WorkLife Law. Thank you so much for having me.
Thank you all.
All right, so we'll dive in talking about why this work is so very important. So you're all coming to us today as employers, and clearly you have an interest in really making sure that you're staying in compliance with the law and making sure that you're doing what you can to support your employees. The reality is that the majority of adults become parents during their lifetime, which means that you're certainly going to encounter workers who are on this journey. And we know that the first 1,000 days, so really from that pregnancy period through the first 1,000 days of life, really can set the stage for lifelong health and wellness. It has an incredible impact for health of both mom and baby. And it's very important that employers are doing their part to not only stay in compliance with the law to protect the health of their workforce and of their business, as well as they playing a role in the health of that family. We know that human milk feeding sets the stage for lifelong health and wellness, and it has a huge impact on reducing the risk of all kinds of diseases and illnesses. It's really important for stress reduction and bonding. It provides a really important opportunity to protect the nutrition and the microbiome of baby and reducing many risks for the lactating parent. It also has an important economic benefit for both families as well as for employers. Next slide, please. So really, in addition to just being great for public health, being great for our workforce and our population, there's a lot that's in it for employers, just supporting pregnant and postpartum workers. There's a very significant return on investment. And so we want to come to you today with this opportunity to learn about how you can really reap those benefits, both for your business and for the families that you work with. We know that 1/3 of working women are mothers, and that by providing this support and being really proactive about comprehensive support for pregnant and parenting employees, you can really attract top talent. You can reduce turnover. It really has a big impact on loyalty of your employees. It also has so many of those health benefits that I mentioned earlier, so it can have a big impact on your healthcare costs for your business. And of course, it increases diversity and talent among your workforce. So we're really coming to you as a resource. So as you're navigating, there's been these really significant changes in federal legislation. There's a lot in it for employers, and also you're not on your own trying to work through that. Next slide, please. So probably many of you are familiar. I know Healthy Horizons has done a lot to educate employers around the Pump for Nursing Mothers Act. And this was an important piece of legislation that was just passed in December 2022. So the Pump Act protects the right to pump human milk at work for 1 year following birth. So this is a really important piece of the picture. When a new parent comes to work, they want to be able to continue human milk feeding their baby or breastfeeding their baby. It's really important that they're able to pump milk, express milk about as often as their baby usually eats. And without that, they're going to really struggle to be able to continue breastfeeding. They're going to have big impacts on their supply. They can risk infection and not have enough to feed their baby the following day. So it's really important. Employers are a really important part of the landscape of breastfeeding support. Back in 2010, the Break Time for Nursing Mothers provision was passed. This was the very first time that federal law addressed the needs of lactating workers. And many of you may know it as the Break Time for Nursing Mothers Law. And that provided the right to time and space to pump during the workday for a lot of workers, but not all of them. So the Pump Act, which was just passed, like I said, at the end of last year, expanded this legislation to cover nearly all workers. So workers who are covered by the Fair Labor Standards Act with only a very few exemptions are now required to provide reasonable break time and a private non-bathroom space for their lactating workers to express milk as often as they need it during the workday. So what this means is that this legislation that you already know, you're familiar with, employers have been doing this for more than a decade. It just really means that all employees are covered. It expanded this protection to about 9 million more workers, mainly to salaried workers. So before, where it was really applying to those hourly, non-exempt workers, now this law extended this over to are exempt workers, meaning about 9 million more employees are now protected. So in industries like education industry, teachers are now covered, agricultural workers are covered, managers and nurses and professional employees now have all of these protections that are so critical to them being able to continue breastfeeding after they return to work. A really important piece to also know about the Pump Act is that it also provided a private right of action. So if an employer does not comply with these very simple basic requirements, an employee can actually seek remedies in court by filing a lawsuit. So this is a really important thing for you all to be aware of. If an employee files a complaint and an investigation takes place by the Department of Labor, you could actually be at risk not only for violations of the Pump for Nursing Mothers Act, but any other part of the Fair Labor Standards Act. So being proactive and really taking the steps to make sure that your business is in compliance is really an important protective measure. And of course, making sure you're avoiding any lawsuits. This is not something that we're expecting to see lots of things happening about. However, it is a real risk. So it's very important that employers are aware of what laws are in place on the federal level as well as the state level, and that you're taking the steps to really mitigate those risks. And of course, what we're going to dive into more deeply today is the Pregnant Workers Fairness Act. And these pieces of legislation really work in tandem to protect employees through the full reproductive cycle. So I'm going to pass it over to my colleague to share about how the PWFA goes beyond the Pump Act.
Thanks, Cheryl. Yeah, the Pump Act sets a fantastic floor for companies, but the Pregnant Workers Fairness Act is a new federal law passed right before New Year's last year that went into effect in July. And the Pregnant Workers Fairness Act opens the door to some much more creative potential ideas about what we could be doing to accommodate lactating and pregnant workers. So the Pregnant Workers Fairness Act applies to anyone who's in your workforce who might be pregnant, lactating, postpartum. Anyone with a condition that's related to pregnancy is covered under the law. And the Pregnant Workers Fairness Act requires employers that have at least 15 employees to provide them with reasonable accommodations. That could be light duty assignments or breaks to express human milk, whatever they need. It also prohibits employers from retaliating against workers who request accommodations related to pregnancy. So that's a lot. Like I said, it's very open-ended. It's an open door. So let's talk a little bit more about what this would look like. Next. Next slide. Great. So the Pregnant Workers Fairness Act, again, it applies to employers with 15 or more employees, and it applies to all of the employer's workers with known limitations related to pregnancy, childbirth, or related medical conditions. So that could be anything from a worker who is undergoing fertility treatment to somebody who had a baby 6 months ago and is dealing with ongoing complications. Anything within that realm, any symptom, need, or limitation that you know about as an employer might open up a requirement for you to provide accommodations. And I should note before we go further that the Pregnant Workers Fairness Act applies in addition to state and local law. So I always want to keep that in mind. I know, for example, California already had a reasonable accommodation law. This would just stack on top of it. Next. So if you haven't been in this context before, you might be asking, what are accommodations? That's just lawyer speak that people like me created to refer to changes to how, when, or where an employee works in order to allow that employee to keep working and meet their health needs. Reasonable accommodations are what this law addresses, and those are accommodations that make those changes without causing an undue hardship for the employer. Many of you are probably familiar with this from the ADA context. It is a very similar principle, although the test of who's protected is quite different. Next. Common accommodations you might have requested by your pregnant or postpartum employees include more frequent breaks. For example, going to the restroom more during pregnancy, or breaks to express milk and access to a lactation space to do it. You might also have employees ask for a different work schedule, different work site. Um, a common accommodation is temporary transfer or job restructuring, or maybe just a modified schedule within that worker's same role. Next. Other frequently asked accommodations are changes to equipment, uniforms, or seating to accommodate somebody who is pregnant or lactating. We also see folks requesting leave. That could be maternity leave, whether or not someone is eligible for the FMLA or not, or it could simply be time off work to allow for that employee to attend to medical appointments. We also see a lot of requests for permission to bring a child to work site. That might come up if someone, for example, is lactating, but they have challenges using a breast pump. An accommodation for them might be to have their lactation breaks with their child instead of pumping. Next. So if you were listening closely, you probably heard me say that reasonable accommodations are those changes that can be made without causing an undue hardship on the employer. So accommodations don't have to be provided if they do that. Undue hardship is very loosely defined in the law, but we know it's judged in relation to difficulty providing the accommodations in light of the resources available to the employer. The question about whether an accommodation would cause an undue hardship is incredibly fact specific. It depends on what that worker is asking in that particular moment and the resources that the employer has on hand, again, at that particular moment. So I always point this out because we want to be really careful to not have blanket policies that say, these are the sorts of accommodations we will provide, and these are the ones that we don't. It requires that in-depth analysis for each and every request. Next. Another great point I hope you'll keep in mind about these undue hardships is that there tends to be a high bar to getting an undue hardship exemption when we're talking about pregnant and lactating employees. That's because most of the accommodations that folks are asking for are simple and cheap. The vast majority costs less than $500, and especially because this law only applies to employers with at least 15 workers, we anticipate it will be rare for it to be a true hardship. We also think that there's a pretty high bar for those accommodation exemptions because employers often already have an obligation to accommodate under other laws. For example, these lactation accommodations, you're not going to be able to get an undue hardship exemption for providing lactation break time and space because you're probably already required to provide it under the Pump Act and very likely under state law as well. So there's a lot of overlap that we always want to keep in mind if you're thinking about whether this hardship might apply to you. Another reason there might be a high bar is because changing existing policy isn't necessarily a hardship. I see employers really struggle with this. Less so the HR department, but definitely individual supervisors or lower level managers think that if it's against policy, you just can't do it. But the law actually requires employers to think about those policies, to reconsider those policies, and whether changing a rule for a particular employee in a particular time-limited situation could be appropriate. The last reason that so many of you are going to need to provide these accommodations is that there's almost always a plan B. We often see back and forth with employees about providing these accommodations, but if the first accommodation an employee asks for might cause an undue hardship, it's your obligation as employers to think about what other changes can be made to meet their needs. So if the plan A doesn't work, there's almost always a plan B, a backup that will work for both the employee and the employer. And we'll talk a little bit more about how that all works next. So the accommodation process, here's where it gets fun. The accommodation process under the Pregnant Workers Fairness Act is incredibly similar to the ADA. So those of you who are familiar with that, we are operating in quite similar territory here. If the original accommodation that an employee requests is not reasonable, it's up to the employer to engage in an interactive process with that employee to determine what other options might meet their needs. And that process needs to be timely. We know pregnancy and pregnancy-related conditions are time limited. We don't want to wear out the clock waiting. The conversations have to be in good faith. Everyone's at the table looking to find a solution. And they have to be truly interactive and a true process, right? This is not just an email saying no and the conversation's over. We are actually expected to have a dialogue here about what could work. It's true back and forth, not just a quick email or memo and you're done. Next. The other important part of this process is understanding documentation. And this is where things diverge a bit from ADA. First of all, pregnant workers or workers that have pregnancy-related limitations don't have to have a disability. Pregnancy symptoms can qualify. So whereas under the ADA context, you might need a ton of documentation to prove that somebody actually has a disability, that's just not warranted in the pregnancy context. So the EEOC, which is the agency who enforces this law, has recently put out their proposed regulations, and they have some pretty clear guidance on documentation. First, no documentation can be requested for lactation breaks in space or other needs that are similarly obvious. So for example, a new uniform for an employee who is in their third trimester and just can't fit their old uniform anymore. Or bathroom breaks. We all know pregnant workers need a lot of those. It would be considered unreasonable to request documentation that applies to those sorts of very obvious situations where you know the worker's pregnant and you know that this is a common pregnancy-related need. But when we're getting a little bit more complex, where the need for accommodation or the employee's limitation is less obvious, you can ask for documentation. That documentation can be limited to describing or confirming that the worker is pregnant, that they have a condition or a limitation related to pregnancy, and that the change or adjustment at work is actually needed for that reason. So it's not the employee's entire medical file, it's not a 15-page ADA form, it's basic documentation that addresses the condition, that identifies that it's pregnancy related, and that a change is needed as a result. Next. All right, let's dig into how this works in reality. Here is a little scenario for us to discuss. Jana works at a call center and she takes lactation breaks. A week after returning to work, Jana's supervisor gave her a warning letter saying that she's not met her weekly call metrics. Company policy says that Jana must improve her numbers quickly or will be facing termination. This is an unfortunate scenario that has actually come through on our helplines a number of times. And from a legal perspective, again, looking back to the guidance from the EEOC is incredibly helpful. The EEOC has made clear that it would be illegal to not adjust an employee's metrics to account for their breaks, breaks that are provided under this law. So Jana should be seeing prorated metrics that are tied to the amount of time that she's actually spending in calls and have been adjusted to account for the breaks that she's taking. It would be a violation of the Pregnant Workers Fairness Act to terminate her because she was taking those breaks and saw a change in her productivity as a result. I should note here that we have some pretty similar guidance from the Department of Labor Wage and Hour Division on PUMP as well. So the two laws are in sync here. The Department of Labor expressly says that forcing someone to work overtime or to change their schedule to work additional time to make up these metrics could be a form of retaliation. So either way, adjust those metrics when your workers have lactation breaks. Do either of you have anything to chime in about the experience of call center workers and how to make this make taking lactation breaks feasible for people like Jana?
The one thing I would say is making sure there's good communication between Jana and her supervisor. We've seen it in the past where they're afraid to bring these things up because they feel like they are going to be retaliated against. So that communication and educating the employer is like so important. So we're hoping people like that are actually watching this webinar and learning.
That's such a great point. And that's one of the reasons why I think it's so important to reiterate that there might be a company policy that says something different than what you're required to do under the Pregnant Workers Fairness Act. So it's so important for employers to make sure that their frontline staff, their managers and supervisors know that there might be a need to bend the rules or to temporarily shift those rules to meet the needs of these workers. Okay, next. All right, here's another PWFA, Pregnant Workers Fairness Act scenario. Shantae is a nurse. She used all of her leave after contracting COVID and is expected back at work 2 weeks after giving birth. Shantae has not recovered from her C-section and is experiencing difficulty breastfeeding. She worries returning to work will mean she loses her ability to breastfeed. Well, right off the bat, I see here two limitations, two needs that might cause Shantae to be eligible for reasonable accommodations. One, she's still recovering from childbirth, and we know that often having a C-section takes about 8 weeks of recovery. So that 2 weeks of maternity leave is certainly not enough to look after her. We also see that she is still establishing her milk supply. She's still trying to figure out breastfeeding, and returning to work early is a big reason that folks struggle with meeting their lactation goals. So if Shantae called me, I would advise her that she could ask for additional leave. That is considered a potential accommodation under the Pregnant Workers Fairness Act. So she could go to her supervisor, go to HR and say, look, I know I've exhausted my FMLA. I know I don't have any more paid time off, but I'm 2 weeks after a C-section and really struggling. What leave can you provide for me? Now, I will say, we also hear from a lot of nurses that there's a terrible staffing shortage right now. If there is a true staffing crisis, a true shortage, she might not be able to get the amount of leave that she really needs. So it could be they give 2 more weeks, but that's all they can manage without sacrificing patient care. If that's the case, the conversation is not over. It's not just, no, we can't give you leave and that's it. Other options should be provided to Shantae, and I'd encourage her to think of some other creative options that can help out. So for example, if she's in a hospital setting, it could mean assignment to a floor that has a slower pace of work so that she's not on her feet in a quite as an intense setting. It could mean a shifted schedule so that she's working hours that better suit her recovery and health needs. It could mean, as she's still establishing breastfeeding, permission to bring the baby to the lactation suite on site, or permission for her to leave campus to have those lactation breaks so that she's able to keep meeting her lactation goals. I could go on and on. There, at one point, I thought of about 30 different accommodations to help Shantae out, and it could mean actually combining some of those, shifting a schedule, giving her a schedule that helps meet her lactation needs and her recovery needs, easing up on the types of assignments she's being given, maybe a little bit of leave. You can stack them. But the bottom line here that I hope everyone will remember is that, again, this is an interactive process. It's not just one and done. There might be multiple accommodations that are going to be helpful to a worker in this sort of setting. All right, next, Olivia is 7 weeks postpartum. Her boss wants her to begin regularly traveling for work again, which will be challenging as Olivia recovers from birth and continues to nurse her child. What are Olivia's options? I think this is another really excellent scenario for thinking through everything that might be available for folks. So again, doesn't matter if the policy is you have to travel. Um, all of these pregnancy related conditions are temporary. We know the EEOC says even if you can't meet one of the requirements of your job, as long as that's for a temporary basis, you should be able to continue working, and accommodations should be provided. So maybe the accommodation for Olivia is to be off of travel duty for another few months as she recovers and as she spends time with her child and continues to nurse her child. Or maybe that means being off travel for a year. If not, if that's not a reasonable accommodation, if for some reason that would cause an undue hardship based off of the employer's analysis of all of their resources, you go to plan B. So perhaps that's the company paying for Olivia to have babysitters, to have a caregiver travel with her so that she's able to have her baby with her. Or maybe there are other solutions. I'm curious if either of you have suggestions of other things that have worked for traveling employees.
The part about the babysitter, I think, is brilliant. We definitely have had companies help with that, or pay for a family member to come along and to help out. And then also the ability for that parent to be able to ship their milk back makes a huge difference if they do choose to leave the baby at home so they can maintain their lactation.
Yeah, I think all of that is really helpful. This is actually an accommodation that I used myself with my daughter. It is definitely, when you're talking about institutional knowledge and how you're putting on an event or being able to really represent your company, it's probably a lot less expensive to pay for a nanny to travel with you than it is to replace that employee entirely. So it's really about, this is something that can be really easy when you're anticipating it, when you're planning ahead. This is a normal part of the life cycle is reproduction. So it doesn't have to be a big deal as long as you're really thinking about it and looking ahead. I think the other thing I'll just flag is that it's important to look at state paid family leave programs. A lot of states are passing and even on the municipal level, state paid family leave programs that you all might be familiar with for your employees. So that's also another place to really look at how you are supporting your employees in the fullness that they need. Thanks,
and one
Jen.
more tip to add is make sure that there's a lactation room wherever she's traveling to. We don't want her to show up and have no place to pump.
That has happened to me, and it is terrible, but I will tell you, I have so much love and respect and loyalty, frankly, when I've been traveling for work and my needs were anticipated. They heard that I needed a lactation space. They make it happen. It's seamless. My respect and commitment to that engagement is through the roof. What a contrast to a worker showing up and being physically in pain and distraught, trying to figure out how to get that lactation space. Great addition. So yeah, those were 3 scenarios on the Pregnant Workers Fairness Act. I think, as you'll see, it is an open door to an in-depth back and forth conversation. It's not a one-size-fits-all piece of legislation. It is premised around engagement with you and your employees. I'll pass it back to Cassie to talk a little bit more about where we go from here.
Thank you so much. Okay, so we're going to go through our takeaways. So if you're going to take 5 things away from the presentation today, first, for the Pump Act, make sure you're meeting at least the basics, preferably more than this. But the basics are having a lactation room that's not a bathroom, is shielded from view, and it must be free from intrusion from coworkers and from the public. Second is provide at least the following for the Pregnant Workers Fairness Act. So first, reasonable accommodations for pregnancy and lactation if and when it's needed. Interactive process for managing requests. So make sure you're having a discussion so you can find a solution that is suitable for that parent in your organization. And your HR and legal team can certainly assist with that. Be familiar with state and municipal laws. Depending on where you are, there may be many more protections than this. So we always like to flag that. Over half of the states in the US have lactation laws on top of Pump Act, for example. Fourth, parents can file complaints. So for the PWFA, that would be with EEOC, and for the Pump Act, that's with the Department of Labor. And then lastly, if you need help implementing the Pump Act or with the PWFA, reach out for guidance. Help is available. Healthy Horizons specializes in setting up lactation rooms and maintaining them. And then WorkLife Law Center has a lot of great guidance around the PWFA as well. So if you want to go above and beyond, these are some sample best practices that you can implement at your company. So first, make sure there's ample breaks. Breaks are a requirement, but make sure this is really easy for parents to actually take the breaks, and there's no cultural repercussions or things like that happening from that. Make sure you have a dedicated room. The rooms for lactation can be shared, but it is a best practice to have a dedicated space. Make sure you have a comfortable chair. We recommend 2 surfaces, one for personal items, one for the breast pump, refrigeration to store human milk, a sink with hot water, a microwave for sterilizing those attachment kit parts, pumping essentials, and a hospital-grade pump are really something that, 1, boosts productivity, but 2, makes parents really happy and grateful to have those resources available. Ensure you have enough pumping space to accommodate all the employees that need it. You don't want to go into the pitfall of saying, I have 1 room with 1 pumping station, I'm all set. When you have 6 moms, that's not going to end well. Make sure you have training for HR and managers and the facilities team, because they're going to be part of your support network, making sure parents are properly supported. And lastly, lactation room servicing on a regular basis is important, because you can put all this effort into setting up a really wonderful space, but you have different people coming in to use the space. We want to make sure it's going to stay nice and productive for everyone. We also have some best practices for accommodations in general. So first, always have an open dialogue. Like Jess shared, it's an accommodation. There's lots of different ways to do accommodations. There's plan A, B, C, D, and so forth. Allow for accommodations that are policy exceptions. That is, totally okay to make those exceptions. Most accommodations are simple and cheap. Josh, thank you for sharing that. $500 is kind of a typical amount for an accommodation. That is much less expensive than any legal action or even the labor put into sending things to Department of Labor or EEOC. And lastly, be flexible. Pregnancy and the postpartum period are temporary. Your employee is not going to have postpartum needs forever. And supporting parents goes such a long way into building loyalty and retaining talent and having a positive image within your company for new parents. We also put together some resources, and we're going to go ahead and put this in the comments. So you'll have all of these wonderful links and resources. So for Pump Act, we have everything here from blog articles and overviews and solutions to the actual text of the law. And then for Pregnant Workers Fairness Act, we have some additional resources as well, including the EEOC draft regulations and a really wonderful guide as well. And with that, thank you everyone for joining us. We're going to go into questions now. So please enter your questions into chat and we'll go through them as we receive them. So first question I see is from a viewer that's asking, what are the main differences in how lactation is supported and protected in the Pump Act versus the Pregnant Workers Fairness Act?
I can jump in on that if that's okay. So the Pump Act is a very, very basic law that I see as setting the floor for the whole country, because this applies to workers of all sizes. The Pump Act requires employers to provide a non-bathroom lactation space. That space has to be free from view from the outside and free from intrusion. So usually that means a lock on the door and curtains on the windows. And that space has to be available. Breaks have to be available for the employee to pump as often as needed. And finally, the Pump Act does that for 1 year only. The Pregnant Workers Fairness Act does not state what a lactation space should look like. It does not state any maximum period of time, and it does not. It is an open dialogue to meet whatever lactation needs that worker has. So at minimum, you have to provide that private non-bathroom space for at least a year. But the Pregnant Workers Fairness Act means that there might be other changes that you would have to provide as well. So for example, if a lactating worker can't fit their uniform anymore, or maybe their job takes them around toxic chemicals. The Pump Act doesn't really address that. The Pregnant Workers Fairness Act says you have to have a dialogue with that employee to find alternative ways for them to keep working while their health is protected. So both laws can be used by workers to get lactation breaks and lactation space. But the Pregnant Workers Fairness Act kind of takes things a step further and says, let's think about what you need beyond those very, very basic requirements of the Pump Act.
And then we have a comment about hotels and that it's really important to kind of understand the need there. Do you have any examples of where you've worked with a hotel and helped them with an accommodation?
I've been talking a lot. Anyone else want to jump in first?
Sure. Yeah, this is actually a situation that we hear about quite a bit at USBC. So this is often coming up not only for hotel workers, but also, again, in the situation of someone who's traveling, they're heading to a conference, something like that. Of course, in a hotel, a space is not usually so much of an issue. We're seeing more and more of hotels who actually have beautiful lactation spaces with like a nice rocking chair or something, but oftentimes it's just simply, there's an extra room that is not being used at the moment. And they're able to make that available. We're really seeing a trend where hotels are a lot more aware of it. This is truly, breastfeeding is becoming far more normalized than it was. I have a 15-year-old. It's very different than it was when he was first born. With hotels, I think the larger issue is really about that time for a lot of employees. So making sure that schedules are being built in mind with them being able to pump about as often as they would feed their babies. So that might vary a little bit depending on the age of their child. And the other thing, of course, is privacy. So you have that space available, but you need to make sure no one's going to be coming in and interrupting that person. The Office on Women's Health has a really wonderful resource. It's called Supporting Nursing Moms at Work, and it has examples from different industries all across the country about how do they make this work to meet the needs of their business as well as of their employees. And there is definitely a hospitality industry section where you can look at how they made that work. So that's a really helpful resource. I'll also point to that there are breastfeeding coalitions in all 50 states. And a lot of these coalitions are really able to provide one-on-one support. So if you're thinking this through and you're like, gosh, I just am really confused about how to make this work, there are lots of resources available. So we're presenting lots of information at you. It's really important information, and you're not alone in implementing.
Next question is, I'm with a very small company with staff in California and New York. We have less than 15 people. What are we required to provide?
So the Pump Act would apply to you for all of your workers, wherever they are. You would have to provide them with a private, non-bathroom space and lactation breaks as often as your workers need it. For up to a year after birth. California has some extra laws saying very similar things, but the Pregnant Workers Fairness Act, I think this is why you mentioned the 15, that was good catch there. The Pregnant Workers Fairness Act applies for those work sites that have at least 15. Same thing with the California Reasonable Accommodation Law. It has a 15 employee threshold. New York doesn't. So when we're talking about New York employers, there is a reasonable accommodation obligation. That is very, very similar to the Pregnant Workers Fairness Act. There's still this undue hardship exemption. There's still this requirement for an interactive process. So my gut instinct is to use the New York standard, even though some of your employees might not be entitled to the full suite of accommodations that the Pregnant Workers Fairness Act provides. It certainly does not foster a good working relationship to know that your colleagues have one set of protections and you're operating on another. So I would use the New York state law and the Pregnant Workers Fairness Act and PUMP Act as your guide for all of your employees, and follow that as much as you can.
And next question is how to support pregnant workers who work in farms and are contracted by farm labor contractors that do not support pregnant and breast/chest feeding workers.
I'm on mute. Hi. Yeah, this is a question that comes up a lot. I mean, and there's definitely challenges that come with accommodating farm workers. It is not impossible. Again, if you're anticipating and you're making a plan ahead of time, it really absolutely can be done. So under the PUMP Act, these rights were absolutely extended to farm workers, including contractors. So there is a legal obligation to offer the support that these workers need and deserve. And there's a lot of really easy ways to do it. We hear from farm workers and businesses who have done things like pop-up tents and adapting different, almost like a porta potty, but it's in the field and it doesn't have a toilet. And there are really creative, cost-effective ways to make this work. So please don't think that they're off the hook. They definitely need to provide the support. I'll ask you, Jess, do you have anything else to add?
Yeah, I think sometimes people get really, really caught up in the issues of contract employment. Independent contractors, not employees, but if you're working with a staffing agency, they are employed by that agency at your request. It can get complicated, and I know that's daunting for folks, but I think it's if you need help figuring out who you have an employment relationship with, feel free to call the Center for WorkLife Law. We can help you sort through that. But I think Cheryl's answer was just so spot on. 9 times out of 10, the problems that we're seeing with employers, it's not that there's no solution there. It's that folks just haven't seen this at work. They haven't tried out the creative solutions like that porta potty shell that you use in a field, or pumping in the cab of the farm truck, that's air conditioned and has covers over the windows. There are many, many ways to make this work. So if you are working with an agency or in association with another employer that is not providing those breaks, I really encourage you to reach out to us if you need help, but also share some of those solutions, because it really can be incredibly simple. I mean, you can go online right now and buy a $30 pop-up tent. As long as nobody's bursting in on somebody who's pumping in that pop-up tent, that $30 gets you compliance with the PUMP Act. So it can be incredibly simple. It just takes some creative thinking and the urge to get it right. And I think everybody here on this call is incredibly excited to sit down with you and work with you to figure out what that might be in your particular setting.
Yeah, it's such a great answer. And with our clients, we see most often is the window covers in the air-conditioned cab of the truck. One tip with the pop-up tent is do make sure you do stake it down, because in windy areas, those can blow away. Next question is, my company has a lactation room. However, it is all booked up during the times I need it. Do I have the right to ask my employer to provide additional accommodations? And the answer for that is absolutely. You need to have access when you need to pump. So please have that conversation, and they should definitely be accommodating you. If they can't do another dedicated room, maybe they can convert another room temporarily, let you use a manager's office with a door that locks, of course, from the inside. And if you need any support with that conversation, please feel free to reach out.
Yeah, and I think the lovely Healthy Horizons team is going to put a ton of links out if they haven't already. I encourage you to use that in your communications with your employers. You know, the Pump Act says very, very clearly that the breaks have to be provided as needed. And so if you're having to wait for that space, that's not as needed. And so they should know. And I hope you get what you need at work.
This is actually a question that USBC receives pretty often from employers as well as from employees, where maybe they work for a very large employer and there are lots of lactating workers who really need to use a shared space. So how many do they need to be providing? Or maybe it's like a retail setting and it's a shared space. So the Office on Women's Health does have a chart, which is really helpful for employers if you're trying to figure out how many spaces do you need to set up. It's important to keep in mind, is it going to be available? Maybe you need a system where they are booking that time in advance so that they know that they're going to have a space at the time that they need it. Or maybe it's that they need to use different spaces depending on where their workplace responsibilities are taking them. Of course, if you have to walk 20 minutes to your space, you're actually losing a lot of productivity from that employee. So having a space that's nearby and convenient for them is actually going to really help you to make sure that they're getting all of the tasks done that they need to for that day. So this is definitely something to keep in mind, is how many employees do you have, how many of them are lactating, and where are they within that space, and what are their responsibilities? So you're really building it strategically. I think that there's a lot of theory, but I will say as well, ask your employee. They're going to know best. They know what they have to do. They know what their day looks like. They know how long it takes them to pump. They know where they need to go. You know, they have all of that. They probably have the most brilliant solution if you just ask them. So that would be my other recommendation is, yes, you're anticipating, you're doing your best to build out a plan, but at the end of the day, it's really about connecting with that worker about what they might need.
I love that, Cheryl. Yeah. Maintaining the lactation space isn't just taking out the trash, right? It's making sure that it's actually usable by the people who need it. Love it.
Absolutely. There is also a law in San Francisco that also specifies number of rooms for employee population and has guidance around, I guess, how far the room should be and things like that. So if you happen to be in San Francisco, there's some really good resources there as well. Okay, so next up, my office employs many women of childbearing age. How many lactation spaces? Okay, perfect. We just answered that one. So the great resource that was just mentioned, and then the San Francisco ordinance is another wonderful resource.
Yeah, I'll just add, Cassie, the same thing comes to mind with restrooms. You know, like if you actually look at the history of the Supreme Court, a women's bathroom wasn't actually installed until very recently. It is shocking. I mean, I don't know the date offhand, but it is wild. Like there is lots of ways in which the world has shifted to be responsive to the needs of workers. You know, we know that our economy does best when our workers are taken care of. So having adequate restrooms, having adequate lactation spaces, and making sure they're in a distance that is reasonable is really what's going to help your bottom line at the end of the day. So I just wanted to add that point.
Yeah, absolutely. Any final questions before we wrap up?
I have a final thing to add. So I didn't raise this. I think Cassie, you might have touched on it just very briefly, but you know, my assumption is that because you are here listening today, you have a vested interest in making sure you get this right. But I do want to flag for folks, especially because, you know, many of you have really big organizations, that culture is important as well. We want to be as proactive as possible about providing these accommodations. Put it in a policy, put it in writing, and train everybody on it, because the other aspect of the Pregnant Workers Fairness Act and the Pump Act that we didn't spend much time on today is that if there is harassment or retaliation because somebody used this law because they requested accommodations or requested lactation breaks, that's illegal. And it can result in liability. It can result in government investigation, and we know we don't want that. So I know those of you here are invested. I hope that you'll spread the word and really remind folks that it's not just doing favors for employees, right? This is a legal requirement, and we want to be setting the stage for folks to feel positive about it. Instead of, Cassie, I think, as you mentioned, instead of raising the risk that there might be career ramifications just because an employee is protecting their health.
Yeah, it's so important that we make it realistic for parents. We can't expect people to work and parent and not have these things in place for them. So thank you, everyone, for the work you're all doing to support parents, for advocating. And a big thank you to Cheryl and Jess for joining us today. We really appreciate all of your insight into this discussion today. The replay will be available on our website at healthyhorizons.com/events. And please follow Healthy Horizons on social at Healthy Horizons Breastfeeding. Thank you so much, everyone.